Hello, my name is Levitt Brown. I am a student at William Woods University, enrolled in the master's program for athletic administration and activities. Today, I am doing a video presentation for my sports law class. This case involves the plaintiff Randy Sallis, who injured his knee while participating in a softball tournament at a recreational complex owned and maintained by defendant, the city of Bossier City. The trial court found that the plaintiff's injuries were caused by the city's negligence and that the plaintiff and his wife were entitled to damages. On or about May 18th or 19th, plaintiff Randy Sallis batted 10th in the lineup and on his first at bat hit a ground ball between first and second base. While running to first base, the plaintiff slid head first into first base. During the slide, 5 feet from the base, the plaintiff struck a steel shaft permanently fixed in the base path that ripped open his knee. Plaintiff was taken by ambulance to Willis-Knighton South Hospital. On this particular day, the field was muddy and wet. However, it is customary for softball games to play under these conditions. On this weekend, however, the fields were extremely muddy and base running was more difficult. This caused Billy Walden, the city maintenance supervisor, to discuss with Dan Farrer, tournament director, about implementing a no-slide rule. However, the coaches, umpires, and players were never notified of such a conversation or thought of this regulation. Bill Walton, the city maintenance supervisor, testified that base anchors, the one in which the plaintiff struck while sliding, is one method of securing base paths to the ground, and that thick mushroom-shaped rubber caps are placed on top of the unused anchors. The caps serve dual purposes. They keep mud and dirt out of hollow shafts, preventing injury to players. Charlie Mason and Larry Hadaway, who played on the plaintiff's team, stated that they observed that Randy had struck a metal base anchor in the running pass approximately 5 feet in front of first base. Both were adamant that the steel shaft did not have a protective rubber cap. Neither Walden nor Carter, city employees of Parks and Recreation Department, who witnessed the accident, could remember whether the protective cap was in place. On December 13th, 1994, trial court proceedings began, and at the close of evidence, the trial court dismissed all claims against NSA, Farrer, Transamerica, which are the tournament director and the insurer. However, the court found the city liable and rendered Randy Sallis an award of general and special damages for his loss. The city of Bossier City and its insurer appealed the decision, stating that the trial court erred in imposing liability alternatively and that the trial court erred in awarding excessive damages. The Sallises answered the appeal, seeking an increase in damages. The plaintiff's argument is that in the maintenance and operation of its public parks, playgrounds, and recreational areas, the city parish owes a duty commensurate with ordinary, reasonable care under the circumstances. The owner and the custodian of immovable property has a duty to keep the premises reasonably safe, and he must discover any unreasonable, dangerous conditions and either correct that condition or warn potential victims of its existence. The appellant's argument, the city, is that the city was unaware of the hazards posed by the unprotected base peg, and that the trial court erred in imposing liability and excessive damages. In order for the plaintiff to be successful in its case, the court must surmise that to satisfy liability or negligence, 4 elements must be shown. 1, the city owed or had custody of the thing that caused the damage. 2, the thing was defective in that it created an unreasonable risk of harm to others. And 3, the city had actual or constructive knowledge or notice of the defect prior to the accident and failed to take corrective action within a reasonable time. And 4, causation. The appeal court's decision. The court found that the appellant's argument that the city was unaware of the hazard posed by the unprotected base peg is meritless. This decision was based on the fact that the city employees installed the base anchors and that unprotected base anchors pose an unreasonable risk of harm and that it failed to implement a procedure to ensure that each unused shaft was covered. And that the trial court correctly found the city was negligent, and this negligence caused the plaintiff's injuries, and that the court correctly granted co-defendant's motion for involuntary dismissal. Conclusion is that the court determined that all 4 elements were satisfied. Implications for athletic directors and activity administrators. Athletic administrators must make sure that their facilities are safe for athletic competition. They must create a culture in which coaches and staff feel comfortable in reporting unsafe conditions immediately to leadership. Additionally, this case demonstrates that even though the renters had insurance of their own, they were not held liable because the renters are not responsible for maintenance or care of the facility. And even with that said, the athletic administrator must be aware that regardless of who is at fault, your department and school will be initially named in the litigation. Thank you for listening to my presentation.